This is Michael Popak, and by the looks of things, it must be Legal AF After Dark. Well, when you have a well-seasoned, sophisticated veteran judge like Judge Mershon presiding over a case, then a little thing like, 180,000 missing pages that get late produced to the defense, like Donald Trump in the Stormy Daniels hush money business record fraud case, doesn't really matter. It's like water off a duck's back. He entertained, I guess that's the right way to put it, motions by Donald Trump to delay his trial, scheduled to start on March 25th, maybe indefinitely. But the judge had another idea in mind about how to keep the wheels on this train and this case moving towards a jury verdict in the spring. And we break it all down on Legal AF. Take a listen.
A lot more to talk about, including, look, a lot has just happened over the past week, hitting with a thud in the Manhattan District Attorney criminal case, right? You had earlier in the week Donald Trump filing this motion requesting an adjournment of the trial date, asserting absolute presidential immunity for the conduct that took place before he was ever in office. I mean, this is the Stormy Daniels hush money case. And what Trump was essentially arguing is that because a lot of his cover-up and some of the comments that he made about the criminal conduct that predated the time when he was elected and disgraced our office, the cover-up almost acts as like a prophylactic, and it immunizes, based on the kind of transmutative properties of Trump's view of absolute presidential immunity, the crimes before he was in office, even those crimes, if they were in office, should not be subject to immunity. So it's doubly frivolous and absurd. And so Trump filed that. Judge Mershon responded right away with a "what are you filing" type of thing. And we all thought, look, Trump's going to make this last Hail Mary move, maybe take a direct appeal to the Supreme Court, beg them to stop this proceeding and try to argue, look, you've got your April 25th absolute presidential immunity argument regarding me based on the Washington, D.C. criminal case. So maybe Supreme Court and Trump hadn't made this move yet, but this is where you and I thought he was going. Supreme Court, step in and please just stop what's happening here in the Manhattan District Attorney case. Judge Juan Mershon, the judge presiding over this criminal case, was like, what are you even filing here, basically? And really kind of wagged his finger appropriately at Trump and said, look, if you're going to file stuff like this, give me notice before, because this is basically a bunch of crap. And Mershon didn't use those words, but that's basically the sentiment that was conveyed. So then you move on a few days, and then you get this notice by Manhattan District Attorney Alvin Bragg, and he says that the SDNY, the federal prosecutors, had previously been subpoenaed about a year ago, or they had been received a request about a year ago from the Manhattan DA regarding certain types of documents which could potentially be relevant in this Manhattan District Attorney criminal case. And back over a year ago, the Department of Justice, through the SDNY division, didn't turn anything over. You fast forward, Donald Trump on January 18th of 2024 subpoenas the SDNY for those same records. And by the way, Trump is within his, I know it's late. You can say he waited until the last minute, but he was within his right. Any criminal defendant could have done what he did there. I'm not trying to be like, oh, I'm supporting Trump. I'm just giving you the procedure here. He was allowed to subpoena it. He sent the subpoena. And then I think at first the SDNY was like it wasn't going to respond. And then the SDNY this week turned over 31,000 documents. We then learned that actually last week they turned over like an additional 71,000 documents, and they're going to turn over 15,000 more documents on Friday. And so you're talking about over 100,000 documents now, 2 weeks before the Manhattan District Attorney criminal case is set for trial. You wonder, what in the world is the SDNY doing? So of course, Manhattan District Attorney Alvin Bragg, through his main deputy who's running this case, Matthew Colangelo, had to go and tell Judge Juan Mershon. Of course, Trump's then going to respond and say, look, this is abuse, this is improper, Passover, Trump will throw everything in. Passover's coming up, and now there's a whole big mess. So you got to delay this case, at least 90 days, if not throw out the case. Judge Juan Merchan, Michael Popak, I think did something appropriate here, though, and very surgical. And I think it shows a complete contrast how Merchan runs his court versus how McAfee runs his court. Merchan said, look, you're all giving me a lot of new news here. We've got trial coming up. I will adjourn trial, meaning there is no trial March 25th anymore. We'll move it 30 days from the date of this letter for now. April 15th. I think the 14th technically is 30 days, but that's a Sunday. We'll move it 30 days. We're going to have a hearing March 25th, but this is not going to be a Judge McAfee style, hearing. I want to see the parties submit timelines that give me each of the documents, every email from the DOJ, so I could understand what happened and how this is going to impact the trial date. And Merchan said, I want to be very clear. Do not talk to me about anything else at this hearing other than this discrete issue. This is the only issue bearing upon my decision on the trial date. Michael Popak, how do you think Judge Merchan handled this? And also, seriously, SDNY? Really? And just so people know, what these documents are, they seem to be the documents, and you may want to get relating to the grand jury and Michael Cohen and things that don't even appear to be significantly all that relevant here. But Popak, take it away.
Yeah, there was some overlapping investigation by the Department of Justice when Trump had the Department of Justice and Bill Barr involving Michael Cohen, a little bit of Alan Weisselberg. I sort of get it from a defense standpoint. If I were a defendant and there was testimony or investigative notes or things that I could get access to in a new trial involving the same people with a little bit of overlapping subject matter, sure, I'd make the argument that I need to see that. I was a little surprised. You and I talked about it in the hot take that we did together when this news broke. I was a little surprised that in this turf war that sometimes exists between the Manhattan DA and the Southern District of New York, for those around the globe who are new to our justice system, state prosecutors, Manhattan DA, federal prosecutors under the Department of Justice, the U.S. Attorney's Office here in New York, they usually they get along better. And I would have thought that if you would have asked me a year ago, Ben, does Alvin Bragg have the entire package with the ribbon wrapped around it of everything the Southern District of New York U.S. Attorney's Office has related to sort of the case or Alvin Bragg, Michael Cohen, all that? I would say, yeah, I'm sure they have it. And they didn't. And they got about, they first got a first gasp of about 70,000, I think, pages or documents. It's unclear exactly originally. And then Donald Trump waited till January, which is really late when you have a March trial, to go issue a subpoena to the Southern District of New York U.S. Attorney's Office. Why didn't they produce earlier? A little bit of it is, I think somebody fell asleep at the switch over at the Manhattan DA's office. I'll say it without Karen being here. and they should have had this whole thing, the whole ball of wax sort of wrapped up 6 months ago, but they didn't. And then there was another, which meant there was another last gasp, actually two last gasps of documents that have come out in the last week, 35,000. It's oh, are we done? Oh, and they're we shook the tree one more time. Nope, 15,000 more came out, but that's it, Judge. So there's a lot of that going on. Now, to put this in context, because I think that's why one of the reasons they like listening to you and me and Karen, we give you some context from practicing law, is that it's not that many documents. It sounds like a lot, to the average person, I don't have 75,000 documents sitting in my house, right? But in lawsuits and in criminal cases, that's not a lot. I'm sure you have too, Ben. I've had the government dump on me somewhere near that number 1 or 2 days during a trial that I had to then figure out how to get through with a search platform in advance of witnesses taking the stand in a case. And that's just the way it is. There's a big distinction between civil cases and criminal cases. You actually, even though there are the Fifth Amendment rights and the Sixth Amendment rights and the due process rights, fair trial rights and all that, you get a lot less in criminal court than you get in a civil lawsuit involving money. In civil lawsuit involving money, I get depositions. I get to take all the witnesses well in advance for hours at length. I get to look at every document well in advance. And if I don't get them, I can argue I need a continuance. That doesn't happen in criminal court, especially in federal criminal court. I find out who the witness is going to be if I'm the defendant against the prosecutors. I find out who the witness is going to be like the afternoon before. Like, oh crap, who's that guy? Where's that file? That's what happens. And there's no depositions generally in criminal practice. I don't get to depose anyone. And then you got the whole, somebody's going to take the Fifth Amendment anyway, so you're not going to really hear about them. So some people, we never really talked about this. This might be something that you and I will do a breakout one day about, a teachable breakout. But there's a lot less that you're given in terms of preparation and material in a criminal case, despite the stakes, than even in a civil case. So they can, and Mershon knows that. And Mershon's like, look, I hear a lot of, like you said, I hear a lot of noise. I hear a lot like last gasp of documents. All right, let's end that. Let's get the documents over to the defense, most of which it looks to you and I as reasonable observers have no real connection to the heart and subject matter, the gravamen of the trial, of the criminal case, and therefore are not Brady-like material or other type of material that is important to go to the defense in order for them to put on a defense. They just are like curious, or they're just like nosy, like, well, what happened to Michael Cohen, or what were the comments about Alan Weisselberg's testimony, or whatever. Okay, great. And the judge is like, you know what? Yeah, all right, I got it. Maybe there needs to be a delay. I'll hear from you guys on the 25th when we were supposed to be together for trial, and I want to have a developed timeline to put this case back on with a proposed trial date. In the meantime, I'm going to temporarily, administratively stay the case for the next, I think he said 30 days. And then we'll all get together March 25 and we will resort out what we're supposed to do to put this case back in spring of 2024. When you said this stands in stark contrast to Hal McAfee, I thought you were going to say your usual favorite, and I agree with you, which is Judge Cannon. If this had happened to Judge Cannon's courtroom, she would have instantly said, trial's off, 2026 at best. This is an outrageous prosecutorial misconduct. Mershon's like, this is like water off a duck's back. He's a New York criminal lawyer, a criminal lawyer first, criminal prosecutor, and then judge. Who's sat on some very high profile cases. This is like nothing. And he's not going to allow Donald Trump, for media purposes, to make it something that it's not, and make a federal case out of it, no pun intended. And so I do like, as you noted, the sober way that and what we're seeing is, I think I said this on a midweek with Karen. If I'm repeating myself with you, Ben, I apologize. But people who watch, who are amateur enthusiasts of our justice system and come to our show, often question in direct messages to me or you or in chats, this is why don't you put your most seasoned and most experienced judges who are qualified and compatible on these kind of cases? Why is it getting randomly assigned to Judge Cannon and Judge McAfee, who collectively, when you added it together, had exactly zero judicial experience at the time they were assigned these cases? Why are they getting them? That's the best you can do. Listen, we got a random assignment system, and there's not something in the owner's manual for our court system that says, well, if it happens to be a former president that's probably an insurrectionist, tried to topple America, then the chief judge gets to reassign the case to somebody who's more qualified. So what we're watching always over and over again is right. What we're watching over and over again, Ben, is that when the wheel does land on a competent, qualified, sophisticated jurist, Judge Chutkan comes to mind, Judge Mershon comes to mind, Judge Engoron comes to mind, proper things happen, things that we expect. They're predictable. Nothing phases them because this isn't their first time they've seen this thing. This is the 400th time they've seen this thing, and they know how to sort it out given the guidance of their appellate courts. But when we put it in the hands of McAfee, who, just to be clear, this is not hyperbolic. McAfee had never been a judge before. He's in his mid-30s. He barely practiced law. He was the inspector general for Georgia for a short amount of time under Governor Kemp, and he got that plum position in Fulton County. He got handpicked. He's standing for election in September. Cannon had only been on the bench for 6 months. And most of that, or less than a year, and most of that was during COVID, where the entire court system was shut down and there was no trials or hearings in front of her. And so these were the two judges that were picked to try the two of the four trials of the century.
That's why, whenever I would go to a mediation, one of the things the mediator would say to the clients who were there in these civil cases, basically, especially if it was a mediation pre-filing, they would say, look, if you have the best lawyer on this subject matter, I still would put your chances at winning somewhere around, even with all the facts on your side, at a little bit 50-50 at most. To someone who had all the facts on their side, who could have the best potential law firm representing them on that issue. And what the mediator judge was trying to convey is that you never know what happens in this legal system. There's random assignments. Then within that, sometimes you have a judge, and sometimes you think you have a good judge, and then the judge disqualifies themselves and they're off the case. Or sometimes the judge has especially in cases that aren't this high profile, a lot of these cases are being watched. But imagine on any given day, when I would used to show up to court in LA Superior, and the judge would have to rule on, and I kid you not, like 40 motions to dismiss on the morning docket that were submitted all the previous Thursday, and now we're on a Monday or Tuesday hearing, and the judge has to issue 40 orders and issue tentatives on that Tuesday. And so, one of the things we can do here on Legal AF is shed light on this, on the overall system and look, that may not be giving you all that much comfort here, but what should give you comfort though is that once we know all the players, and once we are able to know, okay, this is what the pleadings look like, here's the judge. Once you get more of that data, it gets easier to predict here. So when it comes to Judge Merchan, unless it is determined that the Manhattan District Attorney's Office is the party to blame here, I don't think that's going to be the case, but you and I don't know what SDNY is going to say. SDNY, for all we know, they can say, well, you may have responded with a request, but you should have responded with this form or this subpoena. So we don't know what the SDNY is going to say. But assuming the Manhattan District Attorney dotted its I's and crossed its T's, which it claims it did, I think you and I, just to kind of round out this segment, both believe this case is going to trial in 2024 come hell or high water. Now, whether that means it's, April 15th, my prediction was there still is going to have to be things sorted out. So I thought it was going to be around that May, let me pull up my count, my like May 6th is when I think it's going to be. But I think it's going to be around that. I want to get more of your perspective, Michael Popok, on that. And Michael Popok, when you were also talking about those experienced jurists, and you were talking about Engoron, and you were talking about Chutkin, and you were talking about Merchan, I also want to throw in there, of course, federal judge Lewis Kaplan, who I thought handled the case he's one of the most experienced judges that you got. Federal judge, I believe he was appointed in the mid 1990s, 94, 95.
Yes, Clinton appointee.
And, and he was also the judge, remember, who presided over the Sam Bankman-Fried trial as well. And Sam Bankman-Fried actually testified, was convicted, and then sentenced to like hundreds of years, over like 100 years in prison.
I got something to share with you in the audience. I'm going to see Sam Bankman-Fried face to face in a federal prison for a deposition in another case.
Really?
Yes.
Well, you'll have to share that with us. One of the reasons I even brought up Sam Bankman-Fried, though, here is, Donald Trump this past week also filed in the Manhattan District Attorney case. Notice that he was going to be bringing a potential, and Trump's characterizing it as like a semi-advice of counsel defense, not a full advice of counsel defense. So Trump thinks he doesn't have to like waive attorney-client privilege, but he claims that he's going to blame his lawyers for his criminal conduct. It's essentially an admission. Yes, I committed the criminal conduct. It's my lawyer's fault why I did it. And normally in an advice of counsel, you have to testify if you're the criminal defendant, because otherwise it would be pretty much hearsay. And then you would waive attorney-client privilege. And one of the interesting things is Donald Trump cited favorably, this just goes to show you how disingenuous they always are, Judge Kaplan for allowing, in the Sam Bankman-Fried case, Sam Bankman-Fried to testify about a very narrow issue about advice Bankman-Fried received from his lawyers on data retention. Now, when you actually read what Judge Kaplan said, he actually said, I'm only going to let you talk about this very narrow issue on data retention, not open it up for more advice of counsel type stuff. But also, the most obvious distinction there is Sam Bankman-Fried testified. So if Donald Trump's saying that he's going to testify like Sam Bankman-Fried at this criminal trial, well, that would be a bombshell, and that would be interesting.
Let me ask you
certainly
something.
hope that the same outcome is there. You know, Trump wants to cite Sam Bankman-Fried, a criminal defendant who was sentenced to over 100 years. Please cite SBF.
Things always go well, don't they, Ben, when Trump decides to take the stand or make a closing argument in his cases? They're always, I mean, maybe I'm wrong. Maybe I fell asleep somewhere, but they always go well for him when he does that, don't they? Here's a question, putting aside the sarcasm, here's a question for you. Because we have a little bit of a betting pool going on, a little dead pool going on here between you, me, and Karen. And I want to see which side of you're on. Is he going to take the stand? Is Donald Trump going to take the stand in his criminal case? You and I are on the same page.
No,
there's no way he takes that stand.
There's no way he takes that stand. But but for everyone out there, you can address it on the midweek. Karen Friedman Agnifilo, and by the way, has far more experience than you or I combined in the Manhattan District Attorney's Office. And by the way, Salty also Salty, who's also got more Manhattan District Attorney experience than you and I, also believes. So we will keep you posted there, but I think there's no way that he's going to testify at the criminal case. And he's going to be cross-examined about, his posts where he says horseface. Come on, he's not going to. Yeah, so you wrote horseface and you said no affair. So you're saying that you never had sex. There's no way he's testifying.
The difference is you and I are defense lawyers. That's our prism, and so that's Well, there's an example of what we do twice a week, only on the MeidasTouch Network. You knew that. You're right here with us now. Help them get to 3 million free subscribers before the election. Every week, twice a week, we pull together the stories that we think you need to know, curate them for you at the intersection of law and politics. A legal show hosted by lawyers who know what they're talking about. How novel. We're so glad that you're here with us. And if you know everything you need to know about Legal AF and you join us every week, we really appreciate you being part of our audience. From the bottom of our heart. Take that clip, though, and you can use it to help promote the show. Take it, send it to a friend and family member, somebody in your life, and say, hey, you know that show Legal AF I love so much? Here's a clip, and maybe they'll join us. If, by contrast, you have no idea what I'm talking about or what this Legal AF is, that was Legal AF. I am Michael Popak, and I invite you to join us on Wednesdays and Saturdays at 8 p.m. Eastern Time on this YouTube channel or on audio podcast platforms of your choice. Just look up Legal AF. Yes, the name means exactly what you think. So until my next hot take, until my next Legal AF, this is Michael Popak reporting.
Love this video? Make sure you stay up to date on the latest breaking news and all things Meidas by signing up to the MeidasTouch newsletter at MeidasTouch.com/newsletter.